Good morning, everyone. It is 9 a.m. Here come my committee members. Can you hear me? I guess that's the first question of the day. Okay.
Yes.
Hear you loud and clear.
Talking to myself, not sure. All right, let's see. We'll go ahead and let our committee turn on their cameras and get into the meeting. Give it a moment for technology. All right. I'm also going to double check, make sure everybody's been converted over. I think we're in good shape.
Good morning, Kim. Sorry, I stepped away to go to the restroom for a moment.
No worries. We haven't actually called the meeting to order quite yet. So
Do you usually all keep your cameras on during the meetings?
Yeah, I think, well, we can discuss it as a committee. We haven't done Zoom yet as a committee yet, so
Okay.
we will figure it out.
Well, it's nice to meet you virtually.
Nice to meet you.
Thank you. I've been in my job like a little more than 2 months, so I don't know much.
Good morning. This is Suzanne Sleva from the AG's office. I'm covering this meeting for Ryan Sunga. And in regard to the issue about the cameras, yes, the cameras should stay on.
There's your answer.
For the public record. Okay, thank you.
Right, so that the public isn't missing anything, or there's not the appearance that the public is missing something.
Okay.
Now, I will probably turn my camera off at several points because I'm not actually a part of the public body, but I'll be here.
Okay. Great, thanks, you appreciate it. We also have several co-hosts on that are just purely on for the technological assistance for us. So, all right, I'm going to go ahead and call this meeting to order. It is September 17th, 2021. It is 9 a.m. This is the notice time for the public meeting for the Child Support Guidelines Committee. And I am going to start with calling roll. And we will start with Kathleen Baker, who I know is excused. All right, Margaret Chappell. Margaret, I can see you. You're in the lineup.
I'm sorry, Margot Chappell for the record. Yes, thank you very much this morning.
Okay, Karen Cliff.
Present.
Leslie Cohen. Here. Ellen Crecelius.
I'm here.
Jack Fleeman. I know Jack couldn't be here today. Melissa Hardy. Not present. Dallas Harris.
Good morning.
Good morning. Charles Hoskin. Keith Pickard.
I am here.
Bridget Robb. Do not believe she's here. Joseph Sanford.
I'm here.
Jim Shirley. He was excused. Lydia Stiglich.
Here.
And myself. We have 10 present. For a quorum, we require 8. So we have a quorum today. As long as we have a majority, and then the majority of those present can take action. The next item on our agenda is public comment. We are going to utilize LCB staff to assist us with taking public comment.
To give public comment, please raise your hand in your Zoom window or press *9 on your phone to take your place in the queue. Chair, it appears that there are no callers for public comment at this. Oh, I'm sorry. Give me just 1 second. You are unmuted and may begin. We still can't hear you on our end. You may be muted on your phone.
I'm sorry, Stephanie, are you talking to me?
Oh, yes, I am. I'm sorry. You had raised your hand.
Yes, I just wanted to inform the committee that I'm Marshall Willick. I am the observer from the American Academy of Matrimonial Lawyers Nevada chapter. I'm observing with very limited comments. My task is to report back. Some of the current disputes have been reported in Academy meetings, and they've asked me to report back on what this group is doing. We would, as a group, recommend that some record of the deliberations of this committee, I'm not quite sure how to label it, can be recorded or reported in a form that can be cited to the trial and appellate courts. We have been tracking litigation. There are at least a half a dozen trial level courts and possibly 2 or 3 appeals where interpretations of some of the phrasing of some of the regulations is at issue. So some record of what was intended by some of the provisions would be useful to those courts and certainly to the attorneys arguing those cases. Most of the disputes that we have been tracking are reflected in today's agenda. So if action is taken to make a record of what was intended by some of the language used, it may very well resolve a whole bunch of litigation and save folks a whole bunch of money. I had nothing else to report at this time. Thank you.
Chair, there are no callers for public comment at this time.
All right, I appreciate it. Thank you. Thank you, Mr. Willick. We appreciate your participation today. Anytime we can get the private bar participating, we are excited as a committee. All right, let's move on to agenda item number 3, which is approval of meeting minutes from November 30th, 2018 and March 6th, 2020. Are there any comments regarding those minutes?
Chair, this is Margot Chappell. For the record, I will be abstaining on this vote since I was not a part of the committee at that time. Thank you.
You're welcome. Thank you. Any other comments?
I'll be abstaining as well, as I was not present at either of those meetings.
All right.
Well, I was present for them, so I'll go ahead and move to adopt the minutes.
All right. Thank you. Do we have a second?
I'll second.
Sorry, I had to be looking up. Joseph, okay, thank you. All right, all in favor, say aye.
Aye.
Anyone opposed? All right, thank you. Motion passes. And just to clarify for housekeeping purposes, we did have a comment at the beginning from the AG's office that each of the committee members has to have their cameras on during the hearing so that it can be recorded and your presence is recognized. All right, now we have agenda item number 4, which is discussion of the committee's duties by statute, makeup of the current commission members, any seats that need to be filled. It looks like my concern when I created this agenda has been addressed. We have a couple of new legislators present with us today. As I stated, we're a 15-member committee. We need 8 for a quorum. Although there is one housekeeping matter as far as the makeup of the committee goes, which is I am sitting as chair. Don Baker was our co-chair for this committee, and our Don Throne. I just said Don Baker, didn't I? Judge Hoskin caught me real quick. I was just thinking about Kathleen for some reason. Anyways, Don Throne was our co-chair. She's no longer on the committee. She was appointed to the bench. And so we do need somebody else within this committee to volunteer to be a co-chair. The context of what you need to do is you need to help me with the agenda and you need to fill in if I can't be the chair for a committee meeting, or if I need to abstain for some reason from some topic and help run the meeting at that time. Do we have any volunteers or takers?
I'm happy to volunteer.
All right. Anybody have issue with that? I don't know if it's one of those things. I'm not sure it takes a complete formal vote, but let's vote. Is everybody content with Senator Pickard being our co-chair?
I have no objection, and if it
All right.
want to vote, I'll move to appoint Mr. Pickard to be co-chair,
All right, do we have a second?
vice chair.
I'd second.
All right, all in favor, state aye.
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 Opposed? And any abstentions? All right, thank you. Motion passes. Okay, the other part of that agenda item was just discussion of our duties. Everybody that's on the committee originally was given all the materials that are needed. We do have some new members to the committee. So if you are lacking some of the foundational documents that we utilized to get us to where we are today, I am more than happy to provide that to you. It's also posted, the materials and the exhibits, those documents are still posted on the DWSS website, the child support website, so you can access them there. But I would say the critical documents for you to know about are the original AB 278 that gave this committee authority in 2017. There is a final ruling from the Office of Child Support Enforcement, Division of Policy and Training from the federal government. And we have CFRs, and then we have the audit that was done in the state of Nevada that we operated off of for our initial meetings. If anyone on this committee, just reach out to me, please. What I expect out of today is that there are a bunch of items on the agenda. I don't necessarily expect us to come to action on them today per se, but I had to get it out there. I had to get it on the agenda, and we have to at least cursory start talking about it so that at our next agenda, we've got our new committee members educated up on how this works and maybe some proposed ideas on fixes for any of the items that are in the agenda. So I don't expect us to go too long today, but know that our the audit that was done in the state of Nevada was done in October of 2016. So it took us until February of 2020 before we got something solid and passed through all the process that we went through with this. Per AB 278 and the statutory changes and the federal requirements, we're to do an audit on our child support guidelines every 4 years. There is discussion about, does that 4 years go from when we finally got new regs put in place so there was something actually to review, or is it from that original audit date in 2016? I only bring it up just because I think we've got to start putting our eye on the ball about when the next audit will happen, because that's going to give us a lot more feedback. We're working right now on the nuances of things that people have brought to our attention, but knowing what the federal government thinks about the changes we made will only be done through that audit process. And that's when we'll discover those items. I don't know that there's any action item needed on that, but does anybody have any additional comments they want to lend to this?
Yeah, Kim, I'll just chime in briefly. As we walked through the audit that was done, I think that was really done in preparation for the bill. It gave us the impetus. It was an audit, so it met the requirements. But as I interpreted it, or it was explained to me, and I agreed at the time that it's 4 years from the time that the regulation is adopted. So because the requirement was a 4-year audit after implementation. So I think that's been answered in the original language, but we can certainly go back and review that.
Okay, thank you.
And this is Margot Chapel for the record. Kim, staff has informed me that Senator Pickard is correct and that the date of the next guideline review should be February 2024. Thank you.
Okay.
And I think the beauty of that is that it will give us a chance to conduct the audit and have the regulation in place before the next legislative session, so that if it's discovered that any statutory changes are needed, then we can address that in the next legislative session. I think timing wise, it works quite well.
Great, thank you. I'm going to go back to the housekeeping issue. We've got committee members that do not have their cameras on. Let me look at who that is exactly, but we've been
Me.
informed that we have to. Thank you, Justice Stiglitz.
I'm one of them. Kim, I'm home recovering from surgery, so I'm not like fit for public view, but I can certainly pull out of the meeting if that messes it up. But I feel I'd be less messing it up by being off camera, but whatever's your pleasure. Yeah, you got to see me, you got to see me.
Unfortunately, Your Honor, and this is Suzanne Sleva from the AG's office, the open meeting law does require that the public is able to see and hear the
There you
members
go.
of the public body, and I can absolutely appreciate
There we go.
you're attending this meeting while you're recovering, and we all wish you a very speedy recovery, and no one wants you to leave. But unfortunately, you know how the open meeting law is.
I'm here.
Perfect, thank you. And Ms. Kaplan, are you sitting in for DWSS in an official capacity or no?
I am not.
Okay,
Margot
making sure.
Chappell is the DWSS. I'm just here observing.
Perfect. All right, I think we're in good shape now. All right, so I am going to skip ahead real quick in the agenda down to item number 22, which is discussion and recommendations on maintenance of the hearing videos and minutes from the commission and a public location for preserving the intent of the work of the commission. I'm skipping ahead to this agenda item partially because of Mr. Willick's public comment of it being an issue, and it is something that I have been struggling and working with. We're going to need some DWSS input on this, but here's the issue as I know it and see it, which is the ADA requirements for websites, especially for government entities, has caused them to remove a great deal of the content, the original video recordings, hearing recordings, and meeting minutes from the website, from the DWSS website. It did cause problems, and I agree. I mean, that is the legislative intent, quote unquote. The best information people have about what the intent was and the interpretation of different changes that we make to these statutes, and there's nowhere for people to be locating those items right now. My hope is, and I don't know, Justice Stiglitz, my hope was that maybe through the Supreme Court, we could start posting it there, or the law library within the Supreme Court website, or we do have to have a place for this information to live. It can't be put up and then taken back down. Does anybody have any other ideas or thoughts, comments on that item?
Sure, we can house it somewhere. I think it's just figuring out where'd be the best, most accessible place. So we can certainly find a solution for that.
Yeah, I'm a little concerned because in the bill, when I was talking to LCB and we were drafting it, and Kim, you were involved in all of that. We had to decide what executive department the committee was housed in. And so to me, it wouldn't make sense to have all of our official records housed by the body that's going to be ultimately interpreting our intent, looking at that legislative history. I think it should probably remain within DWSS, or we need to house the committee in a different spot. I was unaware that it was taken down. I know that it moved, but I thought it just moved and I didn't have a need to go look at it. So, but I do think that since it's housed in DWSS, it really should remain under their watchful care, just as it the agenda and all are on their website. So should the history be.
This is Margot Chappell for the record, and I actually agree with you. So I think we need to explore. We have, as a department, really been challenged with updating all of our documents to ADA compliance, and so every division has worked towards finding solutions for that. I'm not sure that I agree that the solution is just to remove everything from our website at this point. It's already been done. And as I understand it, one of the primary issues is that hosting the recordings of the meetings takes up a lot of bandwidth on our website that we don't have. So that was another challenge. I did talk with Kathy about getting a YouTube channel like the legislative committees have. And so that is something that we can explore, because then we could just put the link to the YouTube to the meeting and I don't know exactly how that works. So maybe whoever is assisting us from LCB on today knows how we could create, we could turn a Zoom meeting into a YouTube meeting. So that's something I'm unaware of, but I think we can find a solution to that. And we can go back and maybe update the last year's set of documents to being ADA. Well, you don't have any. It's been 2 years since you've met, but the most recent ones could be ADA compliant, and then we can work towards updating the other ones. What is the requirement for maintaining these records on the website, Kim or Susan?
As a committee, we don't have any directive on that. As far as all administrative hearing bodies, I assume all of them try to keep their records. I mean, there's no way that like the gaming board isn't doing that, right? So it's just, you happen to be the branch that the administrative branch that this went through, and then it came down off your website without insight or, you know, comments from this committee about that. But in terms of the ADA part of it, I just know there's an extreme amount of movement right now for the internet, for websites and the ADA compliance. I don't know what all it takes. I do know that Zoom has a closed captioning option, and if that helps cure part of that problem, I'm sure that's part of it, but I don't know for sure.
Suzanne, do you have anything to add? Okay, so Margot Chappell, again, for the record, I would say if we could have until our next meeting, or maybe a month, to get back to you to figure it out. We'll find a solution in some way or another. And I'm willing to take responsibility for the website. I think it's important, and I agree with the senator and others that we should own it, since it is our governing one of our governing bodies. Thank you.
Right,
and I'll just add that one of the things we try to do, at least at the legislative level, is make sure that we have meeting minutes that are citable, so that it's easy for council and the courts to access the language that's used, because of course, particularly in any judicial review, that has to be reduced to written form. There are various applications and online operations that make transcription rather easy, relatively speaking. We no longer have to hire a transcriptionist to listen to the video and try to figure it out from scratch. There's usually a platform that can be used to begin with, and then they clean it up from there. So it's usually pretty quick. And then we can post the minutes to the website, and then the video to the YouTube channel, which I think is an excellent idea. And then we have total coverage. We've got the written form and we've got the video form. Of course, there will undoubtedly be a small cost in the transcription, but I think that that's going to happen anyway. We should probably be on top of that ourselves.
And this is Margot. One of the things that I will explore is whether we have somebody who can do that internally. We have an executive assistant who primarily serves our administrator, but I think she's also one of our resident experts on ADA compliance for our documents. And so I'll talk. I will come up with a solution and have something for you soon. Thank you.
Thank you. I appreciate it. All right. With that, I'm going to leave this on the next agenda for us to come back to for your report on that and some of the options. I think also, I mean, don't forget to keep in mind there's difference between us having to do this by Zoom versus when we can do in-person meetings again, and what the legislative building can do for us versus these platforms. So just to keep it fresh and in mind. I would say, I know you said it's been a couple of years, so it'd be the most recent stuff, but from the family bar perspective, every video of every hearing we had, even the old ones, even though they were a couple of years ago, are relevant for the interpretation of what we have right now. And people are needing it. And I'm getting asked a lot. And I only have so many of them in my own database. So I think it's important to look back to the beginning of this committee. Any further discussion before we move on to the next agenda item? All right, hearing none. Okay, we're going to go into the substantive ones now. Obviously, this is a very long agenda with a lot of items on it. Some issues might be easy, but I would say a lot of them will require us to at least come back to the next meeting with proposed language, even if the idea is great. When I solicited items for the agenda, I almost didn't get actual language from anybody. So as usual with this committee and those that are listening as attendees, your public comment is extremely important. If you come to us with an agenda item that is relevant and something we want to discuss, I can put you on the agenda as a speaker and you can go into greater detail and actually help us and assist us with the language changes. It's not super useful for this committee when we just get the generic, it needs to be fixed comments. So
Kim, if I can just add to that, we are also capable of breaking into subcommittees to do some of those things, and then we can usually be a little more flexible about getting those comments. But you're right, the public comment is the best way to bring this stuff up.
Exactly. So with that said, as we go through these, because there are so many substantive topics in here, what I'd like to do is figure out who's interested in which pieces and who's willing to come back to the next meeting with proposed language changes, or we can, if it's something we want to change versus as we debate each item. So I don't plan or desire to keep us here all day long, knowing that a lot of this is fresh ideas for all of you, and knowing that we don't have that proposed language. But if there are agenda items that any of the committee feels very has a strong opinion that we cover today in great detail, let me know as we're going through it, and we'll continue further discussion on it. Is there anything right now that is important to anybody to take out of order on the agenda? Hearing none, we will move on. All right, agenda item number 5, discussion and recommendations on NAC 425.100 subsection 2, and if the basic needs of the child should be defined. The issue that was brought to me is that what a basic need of a child is being expanded to, space camp, or I don't know, that's probably an old reference. I couldn't think of one off the top of my head, but really, really expensive camps and, fancy clothing, and that's a basic need of the child. my personal opinion of this is we've been dealing with what are the basic needs of a child for a lot of years, even under the old statutes. And judicial discretion is needed there, but any comments on this from anybody else? Judge Hoskin, we can't hear you. I can see your mouth moving and a little bit of noise.
Is that better?
Yes, perfect.
Okay, now I can't hear you. Correct. All right, let me work on technicalities and I'll come back.
Okay, sounds good. Anybody else before we have Judge Hoskin?
I guess maybe just some background for me. We have not got a lot of this in the state program, but I guess I'm just curious, is this something that is being brought up in a more significant fashion than it's always been brought up historically, or something that has changed with respect to our guidelines? Or is it just, they continue to have the same problem they've always had, which is that it's not terribly defined, and so they just desire by the private bar to have it defined?
This agenda item came from Kathleen Baker, who unfortunately couldn't be here today. So it came from a deputy DA's perspective, not from the private bar's perspective. I personally have not had issues with this, but that doesn't say a lot considering how much other areas of law I do, and not just child support day in and day out like the deputy DAs. But Ms. Cliff, have you seen this problem in the South? I'm throwing you under the bus real quick.
I have seen the court entertain the basic needs of a child, and whether or not those are being met by the court ordered obligation before they get into sort of the necessity of discussing the adjustment factors. But I'm not sure why Ms. Baker wanted it brought to our attention for discussion. My position is I'm happy to continue it, hopefully for her to shed some context, because I'm not really sure if maybe as written it's meeting the needs of most.
Right.
But,
all right. I will hold it on the agenda for next time for Ms. Baker to give us more comments. But Judge Hoskin, are you available?
Can you hear me?
Yes.
All right. Yeah, and the only comment I was going to make is this comes back to discretion. And do we want to leave it discretionary or not? The problem that I always see is when we start making lists and we limit the discretion. And if that's the intent of the committee, I'm certainly okay with that. But that's the consideration that I had when reading the potential for this. So either way, I'm okay with it. I just discretion to be able to make those determinations in individual cases. Making that list will make that more difficult.
And Kim, on that point, you'll recall, but some of the committee won't necessarily know that one of the discussions we had very early on was about leaving some discretion in the court. That's why we kind of went the direction we did. Basic needs was a concept brought by the federal rules that we were living under. I will point out that after seeing this on the agenda, I went back and looked, and there are a number of states that have defined, West Virginia and others have tried to define basic needs, but even there, they're talking about shelter, food, clothing, and then they go into a little bit more description about what that means, including safety and other things. But when we, but I think the judge is right that the more detailed we get, the more we will be excluding things that might be basic needs for a particular child under a certain set of circumstances that might be different for another child. And so I think it's important for us to make sure that when we're talking about basic needs, we do leave enough discretion in the court to make sure that that's covered. I think that, much of the stuff that I experience has to do with, whether or not school supplies and uniforms and those sorts of things should be covered under the child support, under the basic needs test versus an extracurricular or an extra school expense that the parties share. But I personally would lean towards not getting that granular in the definition, but leave basic needs. We can give general guidelines, but leave basic needs up to the court to determine. That's my personal preference.
All right, out of due respect for Ms. Baker, I'm going to keep it on the agenda just so she can give comments next time in case we're missing the ball somewhere with what her thoughts or concerns were on that item. All right, if there's no objection, I'm going to move on to agenda item number 6, which is discussion and recommendations on modification of NAC 425.100 subsection 3A to modify the term deviation to adjustment. This is actually probably the only easy thing on the agenda.
I will move to make that change. I think it was something we missed in the first go around.
Margot Chapel.
Was that a second, Margot?
Yes, I second the motion. Thank you.
All in favor?
Aye.
Aye.
Anyone opposed? Anybody abstaining? All right, motion passes. Yeah, that was one of those entertaining moments, right? Where you go, gosh dang. All right, agenda item number 7, discussion and recommendations, clarification of NAC 425.100 subsection 3, and the language established pursuant to the guidelines, and if that language means with or without adjustments per the guidelines. I know that's not the most clearly written agenda item, but it's not me. So
Well, since we just changed a deviation to adjustment, I think it's necessary. We have to make the corresponding change.
the numbers to subsection 3.
Yes.
So for clarification for the records, 425.100 subsection 3 reads, if the court establishes a child support obligation that is greater or less than the child support obligation that would be established pursuant to the guidelines set forth in this chapter, the court must A, set forth findings of fact as to the basis for the adjustment, which is the change we just made from the guidelines, and B, provide in the findings of fact that the child support obligation that would have been established pursuant to the guidelines. So I think the question is, do you do the adjustments and determine that that is what's established pursuant to the guidelines? Here's where I think the confusion comes from, and here's what I see happening in the public right now. And may take some reorganizing of the NACs to get it to read right. But our goal when we set out with this committee was that we needed fewer deviations. So that's part of the reason for the adjustments. But there are items within this formula that are supposed to be part of the actual formula for child support, pre-adjustments. And they are actually supposed to be considered the formula. And so, but they got put in separate NAC code numbers, and part of that is LCB drafting versus our thought process on it. And maybe they need to be moved into one NAC to make that a little more clear, but medical insurance and childcare were meant to be mandatory parts of the calculation of child support. They're not actual adjustments. They are part of calculating child support. They are mandated by the federal government for us to have to consider. And it's not a, whether you feel like it or not one time or another, you have to consider it in every calculation. I don't know if others on the committee, are you following me? This is where I think the confusion comes from though.
Sure, and I've heard the same thing. It might be smart for us to modify that to make specific reference to 425.150, where we actually discuss the adjustments. Because we deliberately limited the adjustments to these because of the problems we were facing, the potential penalties from the feds because of our deviations. It affects the statistical responses that DAFS has to abide by. And so, and thus it affects their funding. But I wasn't aware that we had any misunderstanding as to things like insurance. You're right, that's a mandatory part, and that is part of the calculation. So I'm wondering, would reference to 150 be enough, or are there other things that I'm just not aware of that we need to clarify?
And for clarification on the record, this does bleed into the next agenda item, because I just kind of threw it out there because I think it's the fix to number 7, I think, is what is listed in number 8, which is the issue of what's part of the formula versus what's an adjustment. So back to, I don't want to hold this all day long over something that everybody's thinking about fresh in their minds. But does anybody want to try to address agenda items number 7 and 8 for the next meeting with proposed potential changes? This
Well, I
is
wasn't
where
going to
crickets come in. Too much.
Yeah, I think I understand the concern, so I'm happy to try that. The only question that I have, and I'd like some input from the committee, is that the formula itself, the section with the formula itself, is under 140 is pretty long, and I understand the desire to put 130 and 135 together with that. I just think it's going to be really unwieldy.
Mm-hmm.
From a viewing standpoint. So I'm just looking for some guidance if I'm going to get stuck playing with this.
I had brief moments of thinking maybe at the beginning of additional statutes, we just say this is still part of the, like, add that word in about formula. I don't know, formula.
And I'm sort of internalizing what Senator Pickard said with regard to separating out the adjustment side of it. But as I'm sitting here, I'm not coming up with language that I'm happy with. So I think some time would probably be helpful. But if there's a desire by the committee to put all of the calculations into one section, certainly we can do that. It just feels like from a 30,000 foot view, people are going to look at that and just roll their eyes and not really get into it, even though we have to.
And I wonder if, under the original formula where we were looking at 070 and 080, we had different steps to the formula. It was understood. Maybe we can do a better job of describing it, and it may take some rearrangement. But my thought is that we could, and obviously this isn't thought through, but just Judge, to respond to you, what occurred to me was we could go in at the beginning of 140 and describe what the formula includes and make references to the other sections that then include those provisions, so that we could refer to 130 and 135, as part of the calculation, then step through in subsections the actual calculation, and then we could add as a like subsection 6, we could say, in addition to the calculation set forth above, you would add the things if we thought that was unclear. But I think a reference at the beginning of 140, making it clear that 130 and 135 are also to be added to the following calculations, I think we're done.
Yeah, when I look back at our original notes when we were creating all of this, we had it really clear. This is the formula. This is the pieces of the formula. It was when they got interpreted into NACs with different individual NAC numbers that it didn't look the same. It didn't look as clear. And I didn't think about it at the time, obviously, because we had it in our heads what we were doing.
Right. And one more thought is that the medical support, the way it's currently drafted, is not required. It's not required to be shared. It's just required to include a provision stating. And I don't recall, from my recollection, I'm getting old, but my recollection was we talked about it being actually calculated, but it didn't end up going that way. So it could be that we had a change, and I don't recall that.
I remember that discussion, but my recollection also is that we decided not to incorporate that as a calculation per se, that we left that too up to the discretion of the court in cases, for example, in a joint physical custodial arrangement where you have a significant disparity of income and one parent has the ability to obtain it at a significant discount. It may have made more sense, particularly if, as we look back on the case law, where the Supreme Court said that that's part of the deviations, and the deviations are the exception to the rule. My recollection is that we said we want to leave it up to the court to be able to assign a parent the responsibility to pay for it, even though it may not be the same division per the calculation. So that's my recollection of that discussion.
All right, so to wrap it up, Judge Hoskin, you volunteered to work on this language for agenda items 7 and 8. And I dare to venture to say Senator Pickard might assist you a little bit on it too.
I heard of volunteering, so I think you're right.
Yeah,
I think I'm right.
Happy to.
All right, so we are going to go on to agenda item number 9, unless there's an objection to me moving forward. Hearing none. Agenda item number 9 is discussion and recommendations on NAC 425.125 to determine if the without good cause language needs to be modified to include individuals who are unemployed or underemployed because their household members make plenty of money for the person to not work. I've heard this came to me from a couple of different people saying that without good cause is getting lots of different interpretations depending on who you're in front of, which I would assume is a true statement. I haven't had a challenge on these myself. Any comments from the committee on this?
And I think you're absolutely right. I think that it comes back down to what I said earlier. We can certainly define what good cause is or is not, but then we end up limiting the court's ability to determine that individually. Again, I'm fine with if we want to take that discretion away, but I think that was part of our discussion in coming up with this language was we wanted to leave the trier of fact with the ability to have discretion to make that determination. Because I can think of good cause in one case, which wouldn't be good cause in the other based upon all the other factors that I've considered as part of that. So I think that's, and I don't doubt that people are getting different results, but that's the nature of interpretation as well.
Well, could we beef up in subsection 2E, that's already after income was imputed, but there's the catch-all. And would this be, could we in sub 1, could we just make more of a catch-all for the whole set 125? And that way, like the judge said there, he can think of one situation where it would apply, one situation where it wouldn't. That way we're giving the court more of an opportunity to look at the specifics of the case, but it's more clear to the practitioners and to the court that it's an option.
Yeah, and I think part of this comes from not having the meeting hearings in the transcriptions of our meetings available for any interpretation on this. Because we definitely had that conversation. I know we had that conversation. Then the issue becomes with NACs, we don't have a method of putting comments to it, background comments, etc. We don't have a way to annotize it, and add that additional information. But it definitely was part of the consideration. So, the issue becomes, do we modify the statute, or with this record and knowing we are setting out to fix the issue of getting the record out there for the public, is that sufficient in this committee's eyes versus modifying the statute itself?
I think on that, we'd have to go back and look at what the record is once we get that back up to see if we think it's adequate. It's interesting. I've never had this issue come up in any of my cases until this week, where I've got a client who remarried remarried a wealthy individual, and their kids are, I don't want to say special needs, but they're ADHD. They have they both have IEPs. And so mom decided to stay home in order to help augment that. And opposing counsel is suggesting that that's not good cause. And so dad's income should be used instead. One of the things I do recall talking about was that we don't want to go to the point where we're including the earnings of the new spouse of the co-parent directly, but we're going to take that into consideration. But this is about imputation of income, and it has to be based on the earning potential of the individual we're talking about, not a third party. And so good cause tends to blur that. As a result, I'm thinking I like the idea of leaving this in the discretion of the court, just as we do good cause under Rooney. Now, granted, Rooney also talks about prima facie case and that sort of thing, but I think the concept still applies. Good cause is whatever the judge thinks is good cause when we consider that sort of thing. So if we were to make any discussion or any augmentation of what good cause means, I think we still have to leave it open, just as we do under the Rooney standard, to determine what an adequate cause for that decision is.
I would add a couple of layers to that. I would say the entire impetus of the entire change of child support came from a case scenario exactly like the facts in this agenda item, exactly like it was from Elko. It was a constituent up there. That's what started getting the commission put together. And it was also the impetus of why we put in household income into the list of adjustments for consideration. So we at the time of drafting thought that's how you fix it, was within those adjustments. We didn't think about that it was necessarily to fix it within good cause for imputing income, or at least best I can recall. I do not believe it was.
I think you said it much more artfully than I tried.
Any other comments?
I tend to agree. I don't know that we're going to come up with a better language than good cause. I mean, there's a reason it's used all over the place. It's because it's really a very, very holistic approach for allowing a judge to address it in an individual case where the facts, are going to vary wildly, because the difference between a wealthy person in some circumstances is going to be, extremely different. It could be $1 million a year, it could be $10 million a year. It could change, so drastically. And so I think it is best addressed the way it currently is, with good cause in the imputation part, to let that be addressed, and then the household income adjustment in 150 allows for the judge to address it on the other end to reach the best conclusion that they can. And I don't see a situation, or at least the situation in the agenda, I don't believe isn't covered already in the guidelines. It can be covered, under the judicial discretion as it is.
Additional committee comments?
This is Karen. I think the theme of this agenda is just trying to figure out a way to sort of manage the statewide consistency with the discretion of the court.
Yeah.
But there's some agenda items here that I know I feel strongly about, that we sort of need to define and remove some of that ambiguity. But this is not one for me that I feel that we need to kind of define anymore, but I support whatever the committee wishes to do on this one.
Okay, then for those who are part of the public, I mean, we're going to decide what to do with this agenda item in a second, but if you have a strong opinion on this. This is a good example of, you came to us with proposed language, not just the complaint, but the proposed solution. We can consider it on a future agenda item. And so if this is still an issue and it continues to grow to be an issue, this committee wants to hear about it, and we want to hear about proposed changes for it. All right, is there a motion to do anything with agenda item number 9? Hearing none, then I am going to move on to agenda item number 10 and consider 9. I'm not going to put it on the next agenda unless I receive.
Kim, I was going to suggest
Other
that we
reason.
table it pending further input from the public.
Okay,
Does that require a motion? I think that's just chair's discretion.
I think it's my discretion, so I'll table it. That's
All right.
okay. Agenda item number 10, discussion and recommendations, clarification on use and meaning of NAC 425.150, subsection 1, little f, the relative income of both households, so long as the adjustment does not exceed the total obligation of the other party. So I have heard and received lots of input about lots of issues with the relative income of both households. We were just discussing it based on agenda item number 9, but 10, it's specific to that issue. I have heard of, in my opinion, misuses of it. There's been a lot of discussion about whether it means, does that mean the adjustment can go? We took care of the issue of it can't, you can't go into the negative, but can child support go up from the formula based on relative income of both households? Those are the comments I'm hearing and the issues I'm seeing. Any committee comments on this agenda item?
I'm not, just Judge Hoskin, I'm not clear I understand. Are the complaints indicating they're upset that we're utilizing this as an adjustment factor, or that it's being misused? I'm not clear on the complaint.
The input I received, let's see if I can find specifically. Some of the input I received was just that, if it's the scenario where the spouse has another spouse at home who earns so much money that they don't need to earn money, and does that mean that, say that the payor has a job and is paying, but has a spouse at home that makes tons of money, can their child support go up from the formula based on the household income, allowing them to pay above what the child support formula is? And is there a ceiling on that? Does it keep going or not? That was the comments I received on it.
And I guess my response would be that subsection 1 itself talks about that it has to be in accordance with the specific needs of the child and the economic circumstances. So I'm not sure that solely utilizing F would overcome the court's need to make findings about what the specific need would be, which is why I'm a little confused about the concern. And once again, I think that if we proposed language, it would make it clearer for me what the concern was. I'm not seeing how it hasn't come before me, I guess is probably the better way to say that. I'm not clear on what it is that we're trying to accomplish.
And I can read to you exactly what was received when it was requested to be placed on the agenda. For F, what does the phrase, that was my taboo there, phone on. What does the phrase, so long as the adjustment does not exceed the total obligation of the other party mean? Who is the other party in a joint custody situation? How much deviation is possible based on subfactor F? If my theory that subfactor F is intended to address the new spouse or cohabitant is correct, I would interpret the other party as the new spouse or cohabitant, and the adjustment can't be more than what the total obligation of the third person would be if they were actually a party to the litigation. If my theory is not correct, I just don't know who the other party is, especially in a joint custody situation where they are both obligors whose obligations are offset.
Okay. In my mind, the other party would not be the new spouse. There's two parties to an action, whether it's custody or divorce, not three parties. So I guess I'm not following how the interpretation could go that the other party would be the new spouse. So I think this, I'm not sure there's much to do. If that is the concern, I'm not sure there's much to do, because I think the language is probably clear enough, and I'd hate to add language and have unintended consequences.
Well, Judge, I'll just jump in and say, after AB 115, there may now be more than two, but you're right, it's parties. And that's a term of art. It's well understood. If one person is asking for an adjustment and complaining about another party who's in a spot where they really should be, looking at the relative income, if there's language, the intent was to make sure that we're not giving somebody who has more time than the other child support from that individual. And so that's why we limited it so it does not exceed the total obligation of the other party. So I've not seen any difficulty here. It's been pretty plain in the cases I'm dealing with, including the one I talked about a minute ago. But I guess I agree, though. I don't understand, even Kim, after what you've read, to me, it's pretty clear. We're talking about an individual who is living with someone who is making a boatload of money. They don't actually need this kind of support from someone who's making only a small fraction of that. But at no time are we going to be asking for that the party with the wealthy spouse to be paying in a situation that wouldn't otherwise come up. So I don't understand really what they're driving at, unless we've got a judge who doesn't understand it and isn't following it.
I think it's, again, another one of the issues of our meeting minutes and hearing recordings not being available to the public. I think also, I think I struggled quite a bit with well, I know we did as a committee, we struggled with that. As long as it does not exceed the total obligation of the other party, we messed with those words, we messed with them, and we messed with them because we knew what we were trying to achieve, but we were having a hard time getting there. And I think there may be some creative stuff happening out there, some really creative stuff happening out there.
Judge, have you ever seen lawyers be creative with language?
Never happened, never.
All right, do I have any motions or anything anybody wants to take action on for agenda item number 10? All right, again, for the public, for your sake, if we're missing something, it's your job to come to us, come do public comment, help us, give us the comments, give us what the issues are, but primarily give us some suggested language changes for us to work off of, so we know what it is you're trying to achieve with this. All right. Agenda item number 11, discussion and recommendations, clarification of NAC 425.150 H on ability to pay and use of the regulation. Again, on that ability to pay, the interpretation I've received on it, or the comments I've heard on it, is this issue of because you have more money, it means your child support goes up beyond what the formula was. And because your ability is you have an ability to pay more. That was not the intent, in my opinion, but I mean, we can discuss this as a committee. I do not believe that was our intent within this committee. To adjust it up like that. It was about your ability to pay what is formulated under the formula and whether or not you have the ability to pay that. Am I inaccurate?
No, and I think it comes back to, sorry, Karen. I think it comes back to what the language we put in 425.150 sub 1, that the court has to look at the specific needs of the child and the economic circumstances of the parties. So I don't, that interpretation you just said that because somebody's making a lot of money, let's raise their child support obligation. I don't think that would not be my interpretation of 150.
This is Karen from Clark. I agree. We have ability to pay in terms of setting a child support amount, but ability to pay is heavily used in the 4D program, mostly because of the inception of Turner v. Rogers. Anytime we're entertaining civil contempt, we have to go through those procedural safeguards that Turner v. Rogers case set forth for our program. And it's the same thing that's considered in terms of establishing a child support order, is really delving into ability to pay for the lower standard, because we want to make sure that we're never looking at criminal contempt. And so we have to look at, you know, the same things that we're looking at to establish a child support order. So I agree with you, Kim, and Judge Hoskin on that one.
I'll give you some of the comments that came in on this issue because it came from a couple of different sources wanting us to, and I think, again, I think the purpose of this is the fact that we don't have our prior hearings recorded and out there for the public. So they're needing to hear from us about what our thoughts were behind some of this. But the two comments I received, one was on ability to pay, needing guidance on how to use it. Some masters see it as a catch-all adjustment to only be used in situations where obligor earns very little and informs obligors that payment of child support comes first before all other bills. And I don't, you know, before all other bills isn't necessarily what the ability to pay out of the federal rules were. I mean, the federal rules really are about calculate the child support and then look at what else are they paying. Now, if they're paying on a Lamborghini and that's their excuse that they can't pay that child support payment, then we got an issue. If they're paying rent and their utilities and there literally is no money left at the end of that, or there's a reduced amount of that's available for the child support payment, that's what the federal government was wanting us to look at. Not that child support comes first and then your other bills to determine ability to pay.
Yeah, Kim, on that, I've had both the masters and judges say something along those lines, but I've never interpreted what they said to mean before all other bills. It was always in a context of, you know, before you spend money on the new wheels for your car or something like that. I've never heard it before your rent or other things, but not to say that every judge says the same thing in every case either. But if there is some clarity that is needed to make sure that, you know, some judicial officer isn't saying that, you know, child support has to come before you put food on your table or you know, pay your rent. That's clearly not the intent. And we want to make sure that that's better understood. I think personally, though, that's a training issue.
The other comment that came in when this came in for a potential agenda item was that subfactor H, the obligor's ability to pay as a basis for adjustment. Is this the third bite of the disparity in income apple if the obligor is a higher income earner? In other words, the court takes the higher earner's greater income into account in the formula, then takes it into account a second time in subfactor F, and then takes it into account a third time in subfactor H. I assumed it meant that if child-specific needs are not met by the formula, the court can then look at income to see which parent can better afford to meet the child-specific needs, as opposed to ability, because the parent is a higher earner, the child necessarily has higher specific needs.
I think that's a misinterpretation of the whole section. We're not using this. It was never intended to be an upward adjustment. This was, you know, can they meet the minimum or do they have enough income period to be able to meet all of their necessary and reasonable and necessary expenses and pay the child support? If people are reading, and F has nothing to do with it at all. So if people are reading it that way, maybe we should be a little clearer in the language. But honestly, I think if we were able to add some commentary somewhere to make this a little clearer, that might be all that's necessary.
And I do find that comment interesting because I can follow the logic all the way through to the end of the analysis, but for the fact that once again, they're skipping over the language in the first part of 1, that the court must make a finding about the specific needs of the child and the economic circumstances of the parties. So while if you exclude that, the argument makes sense from a logical standpoint, you can't exclude a part of the to get to that point. So I agree with Senator Pickard. The language doesn't get me there the way that they're arguing that it does. And if it's getting some other judicial officers there, then I agree it's probably a training issue that we need to have some discussions. And I don't know how many times that we've taught this, but maybe we need to teach it again.
Yeah, this is Karen from Clark, and I agree with everything that's been said, but the feds kind of really are stuck on this ability to pay language. And I do think it's because of Turner, because as a 40 program, we received a lot of direction after that case, but ultimately it's an ability to comply with the order. And when you look at it through that lens, it's less of, sort of going up in the child support amount. It's more of just making sure it's a manageable child support. It's an ability for a non-custodial parent to comply, given the ability to work and some of those factors. But if we could leave commentary, that would be great.
I know that's what keeps coming up, that obviously, I mean, we've got things we know we went through process wise and how we got there, and it has been lost a little bit. If I'm gonna not put it on the next agenda unless somebody comes up with maybe, if somebody comes forward, public or committee wise, with some proposed language that might help this issue in order with keeping in mind statutory structure, and we can't put all of our descriptions and our intent into the statutes. And so that's, but if there's a tweak to the language or the statutory language at all that helps with this issue, then we're all ears as a committee.
Would it be beneficial? I don't want to cause more problems. It sounds like we're about done with this, that the language in H say ability to comply rather than ability to pay? Would that solve a problem without creating additional problems? I guess is the question I'm asking.
My only echo in my head is the feds look for that language. That's what they want from us. That's the only thing that like scares me, that we got rid of the one thing they said we really had to have and we really had to make a change on. Some of this commentary also came with things about what was done in the 1980s. And just for a clear record, what was done in the 80s is not what this committee did. We do not rely on the same factors that our prior statutes were required to rely on. We are relying on what the feds have told us we have to rely on. And part of that, I mean, it's a huge income source for enforcement of child support. This is how people get paid. This is how our masters get paid. This is how our deputy DAs get paid. And this is how we collect child support for people. So it's a mandate, it's a requirement, and but if the record is clear that it is about compliance, and ability to pay is about, can you comply? Can you follow the court's order or the formula and pay it and not be in contempt? That is the intent, or this is the way I'm interpreting our intent. Okay. Any other comments on it? All right.
I was gonna say, I agree. To me, it sounded like this is mostly a hypothetical issue and not being something that an actual judicial officer has reviewed and done. At least that's what the comment sounded like to me. And if it is, I think it's a training issue and not the language of the regulation itself. And so I think that the language is very in line with what the Fed has asked us to do. I'd be hesitant to change it too far. You know, my only thought would be, you know, the obligor's ability to pay, you know, the calculated amount or something like that. But I think leaving in the ability to pay phrase is important.
Okay, thank you. Any further comments before I move on? Hearing none, we'll move on to agenda item number 12. Discussion and recommendations on NAC 425.135 to discuss how the health insurance cost should be divided and to include the following language from the prior statutes. Expenses for healthcare which are not reimbursed, including expenses for medical, surgical, dental, orthodontic, and optical expenses, must be borne equally by both parties in the absence of extraordinary circumstances. Comments? I'm waiting to hear which one's Karen's very concerned about. The medical insurance language, I would say, so 135, let me get to the statute. Is missing that language. You know, that is language from the prior statutes. We didn't include it. We did struggle with the medical section quite a bit to get where DWSS felt like it met their duties and obligations versus the private side and what we think about the medical and what needs to go in there language wise. We did want the court to have the discretion to make a decision on medical, but I think our bar and the public is very habitually fixated on 50-50 on everything, and this ability to pay, or that any conversation that deviates from that is hard to handle mentally after all the years of it. You just split it right down the middle. But it is, you know, if you're not saying it, then there's people falling through the cracks and it's not happening. So any thoughts or comments on this? None, huh?
I guess I would just say if there is an appetite to do it, I think it should actually be separate from 425, 135. Because this is more like the, you know, the 30-30 rule and reimbursement and all of that kind of aspect. It really actually isn't about calculating the child support itself, you know, because this is for unpaid, unreimbursed.
This is the unpaid. Mm-hmm.
So this is past insurance having looked at it. It's going to be one-time costs, things like that. And I think since 135 is, I guess, sort of something we're including in the base formula for the calculation of child support, I don't think it's good to fit it there where now we're making our formula more complicated. If there's an appetite for it, I mean, I think our judicial officer is essentially ordering this, although, you know, it tends to be, you know, something that doesn't come in front of the child support hearing until, you know, some other time when, you know, it's already been not covered and they go small claims and that sort of thing. So that just would be my only comment.
Yeah. And this is Karen. And in Clark, this really only comes up once the parties obtain a judgment in family court, and at which point we would enforce. So the 40 program generally doesn't get involved in sort of managing or overseeing the receipts for medical or surgical or anything of that nature. So happy to defer on this one.
Can I throw some people under the bus? Senator Pickard, thoughts on unreimbursed medical being split 50-50 by statute versus
you know, one of the things that the whole purpose of the bill was to move the child support component out of the statute and into regulation to make it more nimble, more able to be modified as needs require. That's what got it, you know, the fact that things were in statute is what made it so problematic within the 40 program generally. because we weren't meeting that 4-year requirement. And so I tend to shy away from the notion of putting anything in statute. But I think Joseph's point is spot on. This is beyond child support. We don't use the 30-30 rule as part of the child support calculation. And even the 30-30 rule, we've bantered back and forth about putting that in statute for years, at least ever since I've been practicing law. And so, and that statutory decision has been made repeatedly not to. So I just, I tend to be one, even though it frustrates me sometimes. I want to leave discretion in the court. And this is a perfect example of where sometimes, you've got people that simply cannot take on that responsibility, and we want to leave the court in a position to use their discretion. So if we were to adopt this language, then we would have to define what's extraordinary circumstances, because what's extraordinary to one judge may not be to another. So I think we're trading one problem for another. And the reason I didn't really weigh in on this is because I wanted to see what others are saying and see if maybe I'm missing something. But I don't see a problem with this. I don't see that this would be necessary, given we have a readily available mechanism in the 30-30 rule that the judges, at least down here in the South, understand fairly well. I have yet to encounter even one of the new judges have a problem with understanding this because it's ultimately an equitable resolution. It's, what's fair. We leave equitable determinations up to the discretion of the court as a rule. And so I personally, I'm not in favor of adopting this language in the statute for the discretion issues and for what Mr. Sanford was saying. I don't think it's necessary.
I'll spin it on you a little bit, just because this agenda item came from the family law listserv early on. There was a big debate about it with quite a few lawyers chiming in that because AB, what was our original bill number? 278 in 2017 deleted this, and we didn't put it back in. And then the debate was whether or not the court had discretion to allocate expenses, unreimbursed medical expenses. And there was a lot of interpretation, a lot of discussion, and different lawyers' opinions. And some opinions were, no, it's not in the statute anymore, it's gone. Others were, it's a court of equity and the court can make any decision that's appropriate for the families. And that would be something to divvy out to the families as they saw fit, and, based case by case and facts by facts. But that's where this all came from. As an issue about it being deleted, but not being readopted by us.
Right. And I know the canon of statutory interpretation, when something is deleted, you assume that it's now out of the statute. I think, though, that it takes it to, I think, an illogical conclusion to suggest that it also removes from the court the equitable resolution, which is the 30-30 rule, which isn't in statute either. It never has been. And so I tend to reject that argument because, and I think I did when it hit the listserv as well, because this doesn't take that ability from the court or take away the ability of the court to issue a reimbursement rule based on the 30-30 rule. Instead, what this did was it left it entirely to the discretion of the court to craft a remedy that was just. And we did have that conversation, and I know you'll recall it. I don't remember who the attorney was when we were debating the, although I think it may have been somebody from the 4D program, but there was this discussion about do we codify the 30-30 rule? And the answer was resoundingly no. That's an equitable resolution or remedy that the courts have. They always have. They will always have. And so I don't think this is necessary, but that's my personal opinion.
The other thing, the other layer I'll add to it is that in part of that same discussion, and as is in the beginning of this agenda item about how health insurance costs should be divided, statutorily within the NACs, we just put that medical support is required to be provided for the child. We did not designate a 50-50 rule. We didn't just, if I remember right, and I'll take committee members' input, but my interpretation is we decided not to intentionally, in case there were scenarios where the child had to have medical insurance and one party couldn't afford it at all. If you say 50-50, you're stuck. There's no ability to work, no option for the court to work within the ability to pay in that discussion. Am I
right? And we discussed that when we were discussing the bill too. And if you remember, we relied pretty heavily on the Supreme Court's decision. I forget the case now, but where they said that the exception, or I'm sorry, the deviation for the child sharing of the insurance premiums were to be the exception, not the rule. And so the discussion revolved around, well, what happens if a parent it's nominal cost, they're able to incur that expense because they make significantly higher money, but the other parent can't afford, even if it's $100 a month that they're paying, they can't afford that. We take that discretion away. So we very quickly left behind the idea that we would divide the cost of the insurance premiums and left open only the out-of-pocket expenses. And then even then we rejected the notion that we would require a 50-50 split in all cases. I'm frightened, frankly, by the extraordinary circumstances language, because I know judges in other contexts have said, not Judge Hoskin, but other judges have said that, well, if you can envision it, it's not extraordinary. And so that would frighten me.
okay? Additional comments before I move on the agenda? Okay, hearing none, we'll move on to agenda item number 13. We've been going for an hour and a half. Does anybody need a break before we keep tugging along at this?
I actually have a Children's Commission meeting starting in a few minutes, so I'm going to have to drop out.
All right, we'll still have a quorum at least. All right, discussion item number 13, discussion and recommendations on adding language to NAC 425.025 on gross income to clarify self-employed income is after deduction of all legitimate business expenses, but without deduction for personal income taxes, contributions for retirement benefits, contributions to a pension, or for any other personal expenses. That is the language direct from the prior statutes on self-employed income, and the reporting party on this agenda item has stated that there have been issues and confusion surrounding that. In my world, that's a given, that that's what self-employed income is and how you calculate it, but any thoughts on adding that language back into the statutes?
If I recall correctly, we spent a lot of time on what we were defining as income, and I think we went through this and decided that we didn't want to include it in. My memory doesn't tell me the gist of the conversation, but I do recall that we had the conversation and we made the determination not to. I'm not recalling what the basis was for that determination.
I find it a little crazy that any judge would say a self-employed income is before you take any of that out. But like your actual income at the end of the day is obviously minus your legitimate business expenses, but
otherwise it's not income. It's not
income. Yeah.
Right.
I mean, it reports weird on tax returns. That's what causes the public confusion with it, right? And maybe to me, this language doesn't bother me. I don't see a problem with it. It may be wordiness for the sake of wordiness. Maybe this record's sufficient. What I would maybe recommend, if anybody thinks this is a good idea, is that we just table it and allow the public to come forth. And if anybody has any strong opinions on it one way or another, we can kind of fill it out at that point. We at least have proposed language. The language isn't problematic as far as I see, but we'll leave it for there right now and to discuss next time.
Yeah, I would support that too. I agree. I mean, my practical experience says that the courts understand that legitimate business expenses are to be excluded because gross receipts versus income are different. And we don't look at the tax. In fact, if you remember from the meeting, I suggested using deductible, a net tax, essentially what the business reports as the net taxable income as a proxy. And there was resounding resistance to that. And, I was looking at it from a practical perspective. How can we get there in the short term? And it was quickly pointed out that we don't use the tax return as a basis to establish income. It's a different set of standards. And so I stood corrected and agreed. And we ended up, Judge Hoskins, the one who put together the bulk of the language. And I thought he nailed it. I don't think this is necessary. I think the courts understand it, but like you, I'm not necessarily really disturbed by the language. I just think it's redundant, it's unnecessary, and if we make it clear the gross income for self-employed individuals is to be the income after reasonable and necessary business expenses, that's good enough for me.
All right, and to be clear, I'm also going to table it because it did also come as an agenda item from Ms. Baker, who ended up not being able to be at this meeting. So we'll discuss it next time in greater detail and just see if she has any other input as to why. All right, agenda item number 14, discussion and recommendations on NAC 425.150 subsection 1E and whether it should be expanded to cover the cost of the parent to travel for visitation. This came from Ms. Baker also, to be clear. Any thoughts or comments on that? Wait for Ms. Baker. Okay, deal.
I personally would like to hear what the reasoning is behind it before I weigh in. So yeah,
okay.
Exactly.
I agree. And again, got to drop off. Thank you all. We'll be in touch on the next one.
Thank you, Senator. All right. Agenda item number 15, discussion and recommendations on NAC 425.150 subsection 1 to determine if the old deviation factor of amount of time the child spends with each parent should be reinstated. Again, this is from Ms. Baker also. Wait for her. I'm happy to table it. Okay. I'm waiting to see which ones Ms. Cliff gets excited about. All right, number 16, discussion and recommendations on NAC 425.150 subsection 1G to determine if the other necessary expenses should be further defined to discuss what is not intended to be covered, i.e. tuition, extracurricular activities, life insurance, etc. This also came from Ms. Baker.
This is Karen from Clark. I'm great tabling it. I do want to say for the record, I don't like the idea of further defining it because I think that the public will determine that those are what's considered necessary expenses, and anything that falls outside of that maybe we didn't consider during that 4-year period. I can't say that we'll be able to capture everything that's a necessary expense, and I think necessary can change over time as a definition. So I'm happy to table it, but I'm happy to not define it also.
What I think I'll do too for the next hearing is I will go into the federal guidelines and determine, I'm pretty sure that language also came out of there, and see what extra color we can receive from that, and comments that we can put on the record so that it can be utilized by the public at that point. Number 17, discussion and recommendations, clarification on the low income schedule, and discussion of use of the table as a minimum child support obligation. I have heard this from probably 10 different directions, not just one person complaining about judges doing that. We did not set a minimum in this committee. That was not the intent to have a minimum. The chart starts at that, but it doesn't mean the court can't go to zero. If ability to pay is incredibly restricted. And that was the prior intent. Any further comment from the committee on this?
This is Karen from Clark. Kim, you just hit the nail on the head. Everything you just said sums up exactly what our intent was. And I have heard it is all over the place, that our minimum is a 0, our minimum is 84, 85, just depending on sort of what calendar they're looking at. So I'm very excited if we could clarify this, whether it's just from our comments or maybe your comment right there sums it up, or if we need to actually have it somehow built in, but we do need to clarify it.
I know I've clarified it in trainings too, and I know the sources of this problem may not be fixable. I don't know if there is a statutory fix for it or not, language wise. Again, it gets back to, you start messing with the language. I don't know what benefit you get from it necessarily if our record is clear. And if it continues to be a problem, I would think or hope that this committee or the public will continue to come to this committee so that we can do something stronger if needed to make the point.
Yeah, and I agree. I think this is a training issue. We had this issue in the South, and actually had a meeting to discuss and to lay out for the masters that there is no minimum. There was no intent for a minimum. 84, 85 is not the minimum. So I'm not sure that we need a fix in the regs, but I think that maybe more clarification may be necessary as well.
I have seen this as well. I've been curious if there's any thought, not so much on actually changing the language or parts on our end, but actually the table itself. If perhaps having a number at the very top that says 0 with 0 next to it might resolve a lot of the confusion for folks, because I think it just starts at 798, and so I think people think, oh, that means 0 to 798, and so I think in some ways, if it just, and my recollection is I believe that's because it's kind of connected with poverty guidelines, and that's probably where poverty guidelines start and all of that, and I didn't make the table, but I think if there was just a line across the top that said, look, we're accepting that if there is truly no income, that your initial presumption probably would be 0, right? I mean, that's, I think, what we've discussed, and it can be adjusted from there if you actually have ability to pay and, some other source of income or something like that. But that was just something I had in mind, or, if we don't want to actually set it at 0 for 0 income, then I think that's something to discuss as well. But I think that's where the confusion comes. And so I don't think that that's our language that needs to change. I think it's a function of the table itself, which creates that confusion.
Well, and
Right.
Ellen, you created the table for us, and are you still doing that on behalf of DWSS? I know your job titles changed some, but.
Yeah, I'm still doing it, and I can certainly add a row with a 0 in it if that helps, or any other kind of
Or
note.
even smaller income increments right below that low number we have there. I mean, it's pretty low, but I like that idea. It also doesn't require a statutory change. That's a DWSS's function to update that chart each year anyways. I don't think there's anything in the NACS that dictates where we start on that chart. Am I wrong?
No, No, and this is Karen from Clark. So Ellen, the way the chart is written, it says, monthly income up to, for example, currently we're at 805 on the 2021 federal poverty guidelines. So any income from 0 up to 805 will populate at that $85. And so the way the chart works, the way it's currently in its current form, for example, if somebody makes 810, because it's beyond 805, but prior to 834, their support is set at 90. And so the statewide calculator, the calculator the state built, as well as the calculator we're using in-house, if you populate the gross monthly income at, let's say, non-custodial parent earns $750 a month, it automatically populates at whatever the lowest number on this table is, which is currently $85. So income from 0 up to 805, because it's written as monthly income up to, will populate at that lowest child support amount, which is 85. I'm not arguing one way or the other, but it will require a change to the statewide child support calculator.
So just to be sure I understand, if it's less than the 805, we're wanting it to go to 0, or are we wanting it to go to some share of that 805?
Right. So that would be the question. Is it 0 if the GMI is 0, or is it, when do we then get to $85? Because currently the chart is monthly income up to 805 is $85. Mm-hmm. Income from 806 to 834 is $90. And so that's how that chart is written throughout. So we would probably need to clarify it a little bit.
Right, and the chart was set up that way, I believe, because it was modeled on something we received from a different state, and that's how their chart was set up. So I'm happy to make any tweaks. I just need to be sure I understand what the desire is.
Margot, is there a fiscal note issue for DWSS in modifying the child support calculator?
Good question. I would like to call on my staff, Kathy Kaplan or Kim Smalley, to answer that question. Thank you.
You're welcome. Go ahead, either of you that's willing to chime in. I don't know if they were listening. Kathy or Kim, are you listening?
So in terms of, this is Karen again from Clark. Kathy, Clark can redevelop the calculator. There would not be anything attached in terms of the monetary issue. It would just be NB Kids and how NB Kids is built with this table. But I don't see why we couldn't just, it's simple to me. To me, is the intent to have gross monthly income at 0, obligation is 0, but anything beyond 0, we would have a child support amount attached to it?
I think I need to defer to Kim on that, but I believe so, that was the intent. Did you not hear me?
Kim Smalley.
We can hear you, Kathy. We haven't heard Kim yet.
Oh, okay.
All right, so let's do this because we have so many agenda items. Let's have Margot, Kathy, Kim. I mean, you can work on your end of that for the next agenda. We don't need to pass this at this moment, but we know what research needs to be done to make it happen. And we can at least put on the record, the intent was that that 80, is it 84 or 86, whatever it's at right now at the minimum, it was not meant to be a minimum. Child support can't go below that. If they're only earning $200 a month, their child support may be less than that. The chart was meant to be an assistance for low-income families. And the desire isn't to make it where it's suddenly, $100. So the discussion and the intent in this committee was that the $100 per month per child was strangling families who were in this low-income scale. And the goal is not to strangle them or force a payment on them that they don't have the ability to pay. And so we didn't want a minimum. A minimum shouldn't be there because you may have a family or a payor where it's completely inappropriate that they even be able to pay the $80. If they have extreme medical needs and inability to work and everything else, it may be a zero, or it may be $40. It's figuring out the right amount for them. But I'll keep it on the agenda so we can discuss the low income chart again next time about what to do with it and in B Kids and the calculator.
Thank you. I have a question for legal counsel, if you'll allow it, Chair.
Yes, ma'am, go for it.
Suzanne, if you're still on the, in the meeting, if we work with Ellen to modify the scale, is that considered out of compliance with public meeting law, since we're both members of this committee?
I would recommend that if you are working on that together, since you're both members of the committee, that perhaps a subcommittee or a work group be formed, and though that subcommittee or work group would be subject to the open meeting law, in that their meetings would have to be noticed and agendized.
Okay, thank you very much. We'll make our decision based on that advice. Thank you.
And for the record, for any of our new members too, we can provide you, the AG's office has some, I don't know if you call them training materials, but they have materials we can give you to assist you with what the rules are regarding open meeting laws. And it's been a while since we've been functioning, and with the new members, the most important thing is exactly what Margot was just saying about communication off the record. There is the statutes and the open meeting laws. I mean, if you hit a quorum, then you got a problem. Where it becomes a problem is, of course, if Ellen goes and talks to somebody else on the committee outside of the two of you, that's when you start hitting those numbers. There will be times when committee members are working on language together. It's not a bad suggestion, but as far as the subcommittee and working groups, but sometimes it's truly just two of us working on some language, and that I don't see as a problem. I mean, we can go through this with the AG's office too, but just do not get yourself in a situation where you reached out to a third member and that third member reached out to a fourth member, and we're getting closer and closer to the open meeting law violations at that point. That's where the problems arise, and it's hard to control that sometimes. All right. But if anybody needs materials, we'll get it for you. The AG's office provided me with a very comprehensive open meeting laws manual, and we can get it to you also for fun reading. All right. Agenda item number, okay, so I'm going to keep that on the agenda. We're going to come back and hopefully have some answers on fixes to the low income table and the impact on DWSS with that. Agenda item number 18, discussion and recommendations on NAC 425.150 to determine if public assistance should be defined, and if so, how to define it. Again, this is a request from Ms. Baker. Any comments?
This is Karen, and I am excited about this one.
Okay.
The intent of the language was to make sure, I believe, and I'll defer to the state, of course, on this one, but was to make sure that the state was protected in terms of parties entering into stipulations, and if there's cash assistance that's being paid out to protect the state in those instances. However, because the NRS broadly defines public assistance to include medical, food stamps, those are all benefits that are not referable to the state. And so we have situations where we have petitioners that are receiving, for example, state medical, not cash. They want to enter into a stipulation. They don't necessarily need our involvement heavily, but they are receiving public assistance as defined in the NRS. We are receiving these stipulations returned from family court because technically they're receiving public assistance. But they're willing to negotiate a lower support amount or a support that meets the needs of their family. So I do believe there is room to redefine public assistance in terms of the NAC to just simply indicate it's the cash assistance that we're concerned about, not all of the other forms of public assistance. But I'm happy to let Kathy, maybe that's not what Kathy is experiencing, Kathleen, but Kathy, is that what we're looking at?
Yes.
Just the cash?
Yeah, just the cash. And it kind of aligns with that federal fee as well. We do define it there. And so we thought it would be better clarified in the NAC as TANF cash.
Okay. So unless there's any objection from any other committee members, what I feel should happen here is perhaps Ms. Cliff and Ms. Baker can propose at our next meeting, propose language on an actual definition to be put in there and how you want it defined, the exact language, how you want it in the statute, and we'll go from there. Okay. And for any of you that are doing any subcommittees and you need assistance setting up the Zooms for that, I will work with you to, well, mainly actually Joy, who is on here. Joy will assist you also and help with setting those up and working with broadcast with LCB or whatever we need to do this. All right. Agenda item number 19, discussion and recommendations on NAC 425.155 to include discussion of individuals incarcerated for month pending resolution of charges, and if the court should set an amount to be paid upon release at the current low income schedule amount. Again, this came from Ms. Baker. We can table it if we need to, but she's been having issues with the incarceration language. From my perspective, from the private side, I never deal with this language. So it is outside of my knowledge range of what the issues are, what's going on. She explained to me she has individuals who have been, sitting in county jail for, serving time, but it wasn't actually prison. And there's some issues about when they were actually convicted and how much time they've served and exactly what should happen to them once they're released. Any additional comments maybe from Mr. Sanford or Ms. Cliff, since you're the two that probably experience this provision more than I do?
We see this often. We enter into stipulations, of course, with all of our local detention centers as well as the prisons. But using that ability to pay analysis, we're still able to kind of get those child support amounts down to zero. But I don't know what Ms. Baker's experiencing, so I'm really happy to table it.
Okay, we'll table it. We know it's an issue. We know it's going to be discussed further. Unless we have any additional comments, I'm going to move on to the next agenda item. Hearing none, item number 20, discussion and recommendations on NAC 425.160 and the legality and enforceability of the obligation of a parent to pay child support for a 19-year-old who is an adult. Judge Hoskin, do you want to, I know this came not from you, but from another judge, but would you like to give some comments on this?
Well, I would love to if I really understood what the concern was. I was just sort of passing along as it came through. Certainly we have the ability, if we fall under subsection 2 is what I'm actually looking at, well, 1 and 2. If they're still in high school, I still have jurisdiction, and that's always been the case with regard to that. And I know that there's other areas where we can take that up to 21, depending on how we look at that. But I'm not sure that I agree that we need a language change, but I wanted to bring it up because it had been raised to me with regard to that. I think that I can, under the language we have, I still have that ability. I understand the argument that they're an adult, but I have jurisdiction under several statutes, even once they reach the age of 18 and emancipate based upon certain factors. So I'm not sure I'm the best one to argue to make some change, other than I was the mouthpiece to pass it along.
It is, I think the argument is pretty analytical. It's a high level analytical conversation about forcing somebody to support an adult. Although we have that in many scenarios under our law when it comes to guardianships and protected persons. When you're still in high school, I kind of consider you still a protected person. You're not mature yet, but we have many scenarios where people are forced to do so, but who you're forcing is not the 19-year-old, it is the parent. And under the parent, you had jurisdiction over through the divorce or the custody action or whatever action brought them in front of you. And I think it's, if they really think it's an issue, it might be better suited for the Supreme Court to analyze for us. All right, I'm going to be taking that off the agenda again for the public. This is an issue, or anybody has proposed research or anything to propose to show that we are wrong on this issue, we are happy to entertain it. Of course, the 19-year-old language came right out of the old statutes. Nothing's changed for us in that regard. Agenda item number 21, discussion and recommendations, clarification of NAC 425.0251M, the inclusion of alimony in gross income in the regulations versus NAC 425.0252 that does not exclude or deduct alimony paid from the obligor's income. Okay, I know we need to work on the alimony language. That has been obvious from day one. I also know that the alimony language was not thoroughly vetted through this committee. It came in through DWSS once our recommendations went out from this committee, and they did their public meetings through DWSS for the actual enforcement of or adoption of the administrative codes. And it was considered an oversight at that point, and it was thrown in at that point. It was thrown in without full analysis and discussion. I do think it needs to be worked on. I do think we need to come back to the table on this with proposed language and propose recommendations on how to deal with it. And I say to the public, and I know within our attendees, we have some prominent family law attorneys that are present today and listening right now. We need your assistance on this. We need you to come to this committee with some proposed language, with some proposed suggestions on this. And we need to go through it thoroughly. Any comments from the committee on this agenda item?
So just so I understand, Madam Chair, your proposal, we're looking to take a deep dive into this one is what we're looking to do, just not today.
Correct. I want us to come back prepared to talk about it in depth. I mean, if anybody's got anything they want to throw out there for today, we're all ears. I'm not going to cut you off, but what I'm saying is I really want everybody to wrap their head around this issue and come back prepared to really discuss it at the next hearing.
Which I think is a good idea.
And public, reach out to us on this. Come to us in public comment, or come to us with a proposal that is so detailed and well thought out that I make you a speaker during our hearing and you get to talk to all of us openly versus just 2 minutes during public comment. I'll take it. I'll take all that work product and elbow grease that anybody wants to put in. All right. We already did agenda item number 22, so we'll move on to agenda item number 23, discussion and recommendations on the language in NAC 425.1153 for joint physical custody in the recent legislative proposal to change the language to 1/2 of the difference versus the full difference in child support values. Senator Pickard is not with us right now, and that was his proposal during the legislative session. I know this is a heated debate. I would say this is also one that I want to say I'd like us to have a good discussion on. I would like the public to come back with comments on. I would like us to actually dive into it some. We did discuss this some during our committee meetings. I'll tell you just my personal position and voting position on it. What I think about it is that I think it should be changed, but part of that's based on you're calculating my child support. I could write a check and you could write a check back to me in a joint physical custody scenario, and it will be the net result is not that I'm paying, it's about what is fair at that scenario. Am I supposed to be gaining extra money because I had the smaller child support amount, or am I supposed to gain half? Is it supposed to be balanced or not? But it's worth a discussion with Mr. Pickard here or Senator Pickard here, because I think that's appropriate. If everybody's okay, I'm going to table that.
I just had a question.
Mhm.
I did not review the legislative proposal when it came out, but is the example, could you give an example with some numbers of what the difference would be so that I can make sure I understand exactly what the difference is? I
Yeah.
understand what it is now, 100% at the full difference.
The full difference, so it'd be half of the difference instead to balance it.
So if one obligation was 600 and the other obligation was 400, right now payment is 200 because that's the difference.
Mhm.
And then now the plan is, since it's 200 difference, it would be $100 payment. Is
Right.
that so the person?
So that you have the same amount of money in your pocket on both sides at the end.
Okay.
Very much like a balance sheet in a divorce action, but there's a lot of thoughts and a lot of opinions about this. And some of the opinions come down to, well, now the recipient is receiving less money and that's not fair. They should receive more money. Well, should they? Is that really what the analysis was? Is that what child support's about? I don't know. There's a lot of heated discussion on this topic, and the legislative proposal, and Senator Pickard's not here, but part of the proposal was to just do it through legislation when it needed to be done through this committee. So we're going to have a discussion about it and thoroughly vet it and put it to bed so that we know exactly what this commission's perspective is on it, instead of saying it was untouched and not discussed. All right. Agenda item number 24 is discuss and approve ideas for future agenda items. Does anybody have anything that needs to be added for the next agenda other than what I've already stated I will keep on the agenda?
Margot Chappell, for the record, I would recommend future agendas. Make sure that any topic on any number is all consolidated. That would just, I think, make it easier for discussion. I would also recommend after every agenda item that we put public comment so that you can get public comment on specific agenda items as well. And Kim, I'm happy to work with you on the next agenda for those as too. Thank you.
Okay. Other thoughts on public comment in between each agenda item? Okay, I don't mind.
Can I clarify, Kim? And that would be only on the items where you know you want public comment, obviously. So yeah, so we don't have to do it on every single one, but just to make sure that if there's something that the public requested and you have people who are on the call or on Zoom who would be valuable resources to contribute, at least they can, and we can allow it. And the other, I just remembered the other recommendation that came from staff too that would be helpful is to have the agenda items aligned in order in the statute or the regulation, just because it's easier to follow. Again, I can help you with that. We can consolidate those agenda items for the future. Thank you.
Okay.
I will just say, and obviously we'll defer to our AG folks. Typically, with the way the open meeting law works, you either choose to do public comment at the beginning, at the end, or public comment after each action item. I'm a little concerned with doing after some action items, but not all. I mean, typically most, we don't have a problem in this commission with an overabundance of public comment that derails the meeting, and so I don't see a problem with having a public comment after each action item and at the beginning and end, which is fairly common in a great number of public bodies. I just wouldn't want to have it on specific agenda items, just for that reason.
Well, I would give an example, the items we covered in the very beginning about the makeup of the committee, there's not any need for public comment on that. It's not actually statutory change. It's just our, in-house behaviors and work. I will say that at times, the beginning and end public comment sections often are not relevant to much of the agenda. And so, if we have that repeat every single time on every single agenda item, which I know there are individuals that would take that opportunity, which is, I don't have a problem with it. I just would rather give a slight bit more time at the beginning and the end than, over and over and over again.
Yeah, and if I can I don't know if it's a suggestion or just reality check with regard to this. If we can have a way for somebody to say, I would like to comment on agenda item 20, and then we know that rather than waiting after each agenda item, if that's the direction that we're going, are we required, and certainly this is probably a legal opinion, are we required to do it after each one, or we've been doing this committee for years and having it at the beginning of the end? Have we been violating something by doing it that way?
And this is Suzanne Sleva from the AG's office. No, you haven't been violating anything. The public body has the option to have public comment at the beginning and end, or after each item. In my experience with the public bodies I represent, I mean, and this is just my opinion, I think it works better to ask for public comment after each item. That way things are fresh in people's minds, they're taken in context. But that's just my opinion. You can do either.
Well, and I as chair can say that the public comment between the items has to be about that item and not allow people to discuss the whole agenda every single time between every single agenda item, right? So the beginning and end can be the more generic or additional new ideas, the things they want to provide us idea wise. As long as I can say, okay, I'm going to take public comment, it has to be about this agenda item in order for, right? Okay. And so I can cut them off if they start talking about other agenda items at the wrong time.
Yeah. Or your dad could cut them off as well. I've done that too.
And Suzanne, the other option might be to put a time limit if we wanted to put a time limit on a public comment, correct?
Yes, the public comment can be limited.
So Susan, another legal question, so we know how we're operating. If I say I'm giving 2 minutes, but I still have the discretion as chair, if somebody's given us really good data and I need more for them, I can allow them to have more time? Or do I have to let each person have the additional time?
I see. I think that's kind of that's a bit of a slippery slope, because if you do that for one person, I do think that makes it much more difficult to end the public comment of someone else whose input may or may not be as relevant or whatever. I don't think it's a good idea to do that. What you can do is say to the person, yes, that's, thank you for that information, for that input. Perhaps when we discuss future agenda items, that is something we can put back on the agenda for further discussion.
Right. Well, and I can put that person as a guest speaker on the agenda as long as it was agendized versus within public comment. So that's the way to deal with that. Okay.
Exactly.
Got it. Okay, everybody, especially our new members. This is the fun of this. we're gonna stay on the up and up with this. And for the public that are listening, we're doing our best. And we really, really encourage you to reach out to us. We really need you. And so back to future agenda items, we got some suggestions on methodology. Any specific statutory changes or items within the next that you want me to add to the agenda for the next time?
Kim, at some point, I would like to hear from TWSS as to, and this is maybe just for me and maybe everybody else understands this and I don't, but I was a little inundated with questions and concerns last time we finished up, and it took so long to get to the point of promulgating the rules. If we can get some information in the committee and make it part of the record as to what happens when we suggest new changes and how that process works, so that's on the record and we don't have those issues in the future. And I don't know if we can do that or not under the way we're doing this, but that was questions that I keep getting asked as to what happens. I thought you guys were done. Why aren't we don't have this yet? And those kinds of questions. So if we can get some information to the committee, then I think that would be helpful.
So in terms of what happens here, and for those that are listening, especially in the public, our job as a committee is to make recommendations to DWSS as to changes we think should be made. We have DWSS as a member of this committee so that it's not a shock or complete surprise to them, or we're doing things that they didn't participate in and assist with. But once we create a report, now last time it was a complete revamp of all of the statutes. And so it took us a long time to get to that report. We had a good 22 meetings, long meetings before we got there. And we're not having to do that anymore, thank goodness. But as soon as we have recommendations, now I wouldn't send one recommendation, like if we have 10 recommendations, I wouldn't send them separately to DWSS because they're going to have to go through the same procedural process as last time in order to pass them. And so it's better if we get at least, a group of edits together at one time, propose them to DWSS. DWSS then has to follow their own administrative rules on passing, administrative code changes within their department. And so they do public hearing, the public comment for the edits. And I think it was, well, last time what happened is there were edits. And so it had to go back to a hearing again, and then there were edits, and then it had to go back to a hearing again. So that's what took longer. Once the DWSS passes it within their administrative process, it then goes to the legislative LCB, to the legislative, Assemblywoman Cohen, help me with this. The interim committee is the
Commission.
Say it again.
Ledge Commission.
Ledge Commission. My goodness, that was basic. Ledge Commission, and Ledge Commission reviews it, has to have public comment on it, has a hearing on it before they pass it, before it gets put into, and once they pass it, then we're good to go. It takes a little while, obviously, for it to actually show up in the NACs online, and then that becomes a different issue, but we'll have an official change of the statutes at that point. It is a process, people. It's still less of a process than waiting every 2 years to make changes and have these ongoing continuous discussions about what's needed in the child support statutes. So
And Kim, if I could clarify too, statute is actually the law. So that's the NRS, and then the regulation is the NAC. And so statute requires acts of legislation, whereas regulations, it's actually, there's a season for it. So we can't do regulations during the legislative session unless they were already begun before December 31st of the previous year. So there's like a regulatory season, if you will. And that starts July 1st after session is over, every session. I believe it has to do with odd years, same as, so basically during even fiscal years, so 22, 24, that's when we can start promulgating regulations. And it is quite a process. And I will say that during COVID in particular, with everybody outstationed at LCB, it did take longer to get back our suggested edits and that sort of thing. So we can review the process if you'd like. I'm also happy to answer any questions under the public comment section of this. And I'm sure maybe Suzanne has information or knowledge about the regulatory process, but it involves other parties outside of DWSS, and we don't have control over the timelines for that.
And I don't have anything to add to that, but that's my understanding as well.
So to piggyback on that, part of the reason for now is because end of session, interim session, all that type of stuff. It is part of the reason that I want to set our next meeting as soon as possible, because I don't want us running into the next session before and not being able to get this stuff passed before next session happens. So I'd love for us to reconvene in the next 2 weeks or so, 2 to 3 weeks. What does the committee think about that?
Well, personally, I need some time to get some language together that I've been assigned to do. So I would prefer the 3 weeks, given what my schedule looks like in the next couple of weeks, but that's just me. And we can table if we're going to do other things. We don't need to wait for me on that if we're going that direction.
So that would be about October 8th. We have been doing Fridays within this committee. Part of it is our judges seem to be a little more accessible, even though today we didn't quite get everybody.
I will be out of the office on October 8th, but I could have Kathy participate if she's in the office. And although I'm thinking she told me she might be off that same day. Kathy, can you chime in? And I should clarify, that is, if I was just realizing I didn't get any bylaws or anything on this committee, so I'm not sure what your policies and procedures are on proxies either.
The pursuant to the way the statute's written from the AB. Oh, it's been a while since I looked at that, sorry.
278.
AB 278. The way we interpreted it was that you could have a proxy. And we had that as an opinion from the AG's office early on in this committee.
Great,
We
thank
were
you so
having
much.
that issue, yeah. As long as it's a proxy that's, gonna know what's going on, and Kathy is one of those for you. So, all right, well, for right now, tentatively, I'm setting it for October 8th. I'm only saying tentative. It is set for October 8th. If I find out we're not gonna have a quorum, then obviously we'll mess with that date. We need to have a quorum. I don't want to waste anybody's time. So we'll go for October 8th unless we've got anybody from broadcast from LCB believe that will be problematic for us to do another Zoom on that date. I don't know if they're listening. They're here just to make sure we don't have problems. If not, we have several means of doing electronic. Right now, we still are not allowed to enter into LCB, into the legislative building to conduct these hearings right now. So October 8th will be the next hearing. Anything else on future agenda items for that meeting? Okay, reach out if there's anything you want placed on the agenda. We'll move on now to agenda item number 25, which is our closing public comments. Public comments will be limited to 2 minutes. And if I can have either Stephanie or somebody from LCB assist with that.
Yes, sure. Hi, this is Cindy with LCB. To participate in public comment, please press the raise hand in your Zoom window or *9 on your phone to take your place in the queue.
All right, Mr. Willick, I believe you are unmuted at this time.
Thank you, Ms. Surratt. A few observations to answer some questions that were raised by commission members during the meeting. What the members of the bar who have asked for a better record are looking for is not so much the videos of every discussion or the transcripts of those discussions, out of concern, mostly out of sheer volume, but something more easily citable like minutes or an analog to a legislative record, as Senator Pickard suggested. On the question of whether good cause includes marrying a rich person, there would seem to be a little confusion as to what the issue was. Part of it is whether the regulation should include some mechanism for how to deal with that question if it's raised. Some courts in the real world are simply looking at the income of the new rich spouse and substituting it for the income of the other parent, causing prenups and postnups, attempting to shield that income from consideration. Other courts are considering imputing income to the non-working spouse in accordance with what they could be earning if they were working, which would be more in line with prior case law. The question is the focus of the regulations and what a court is to look at when it runs into the situation. And some of us with rule drafting experience could propose language if it's desired. 425, 125F, there seemed to be some confusion as to what the issue is in the real world. What's going on out there is questions about the closing words of the existing regulatory language, that exceeding the obligation language. To answer Judge Hoskins' question, some courts don't know what it means. If the cross obligations would be, say, $100 for party number 2, some courts are saying that they can adjust based on wealth so that the obligation is 1,000. This is happening in the real world. So it would be useful to have some clarification of that language, because what this commission may think is totally clear may not be to other courts. It would be useful to answer one question procedurally that was asked, to have comments per agenda items rather than overall at the end so that people can remember what the discussion was.
All right, Mr. Wimmick, you've hit your 2 minutes. I encourage you to reach out to me with written input or suggested language changes that I can propose on the agenda and have it on the agenda in a way where we can utilize it. All right. Broadcast, do we have any other public comment available to us?
Chair, there are no more callers for public comment at this time.
All right, thank you. Mr. Wilk, I hate to cut you off on that, but as you heard during our discussion about about fairness and what I'm supposed to do and the setting of time limits for public comment, even though we don't have anybody else giving public comment right now, we are going to work on ways to get that input into this agenda and get that information in. So on any of these agenda items, and everybody that's listening and everybody that's in the public, you know, you can propose, you can give us written testimony, we can attach that, we can make it part of the agenda so that it can be considered by this committee in great detail at that point. And proposed language changes are always welcome. We are more than happy to contemplate them, and I can get them to put together in the materials to go with the agenda, and it's far more efficient for us. Because you can see some of these comments came from people, individuals that aren't even present today, are not here for public comment with us today, which makes it hard because we are trying to interpret quick emails that I received and put into an agenda. And so we do need that input. We do need that colorful information on those. I will next time break out the agenda so there's public comment for each item in the agenda. And that way, for example, Mr. Willick, who's very helpful to the family bar at all times, can give us comments for each section instead of just that 2 minutes at the end. So we will get this cleaned up. We will get to work on it. And anything else that we need to do? Did I miss anything administratively? I will take a motion to adjourn.
I move to adjourn.
Second.
And
Second.
all in favor?
Aye.
Hi. Thanks,
you.
everybody.
Thank you, everybody. Appreciate you.
Take care. You too.
Bye.
And touch base with me, Kim. Let's talk soon.
Deal.
Bye.